Hello everybody and welcome back to Investigations, and we are going over how to do the post-investigation report and testimony and stuff today. So as always, here's our funny picture of the day to start us off. Gotta love funny people like that, right? Alright, so one of the most important pieces of any investigation is the final report. The final report is the kind of summary of everything that's been done for the entire investigation. It gets handed over to the prosecutor in one giant package, and that thing has to contain everything the prosecutor needs to know in order to prosecute your case that you've just spent so many hours and hours and hours working on, right? So you should try to do things in chronological order in the final report, just to make it easier for the prosecutor to kind of follow along with the story and the investigation and the process and all that. So it means you want to start with the original complaint, right? If that came in over 911, you could provide a transcript of the 911 call, or in the 21st century, you can just attach an audio file of the call itself, or both. The preliminary report, i.e. the first officer on the scene, what did they see, what did they witness, what evidence did they immediately find, etc. Then all the follow-up reports, the investigations, the other officers did this, an officer arrested the suspect at another time after the initial call to the thing. All those follow-up reports. And again, try to do these all in chronological order just to make it a lot easier for the prosecutor to understand kind of the story, right? You want to make sure and get a copy of all statements and confessions and admissions. So keep in mind there is a difference between an admission and a confession. An admission is just, yes, I was there, or yes, I own that car, or something that's not necessarily criminal, whereas a confession is, yes, I committed that crime. Yes, I punched him in the face. Yes, I stole that thing. And statements from witnesses and victims and all those things, compile all those together. Lab reports, make sure you have, if it's a death investigation, make sure you have the coroner's report. Make sure you have any, digital forensics report, ballistics report, all those things compiled together. Have a section for photos and sketches and drawings and all the other kind of graphical material. Whether it's photos of the crime scene, mugshots of the offender, sketches of how the offender described the events during an interrogation, any of that stuff put in there. And then, of course, one thing that a lot of people forget is the summary of exculpatory evidence. So remember, inculpatory is evidence that tends to show guilt. Exculpatory is evidence that tends to show innocence. And we want to include that summary of exculpatory evidence for a few reasons. But most importantly, we want the prosecutor to know every facet of the case, not just the ones that we think they're going to want to know. Okay? Now, who are we giving this final report to? The prosecutor, right? In the United States, there are prosecutors at every level of government, just like there's, local, state, and federal courts, and local, state, and federal law enforcement. There's local, state, and federal prosecutors, right? So the prosecutor's office is kind of by design separate from law enforcement. It's not part of a law enforcement organization. Often they will have their own investigators. So you might be working with other investigators on a case or a certain investigation. But the other investigators usually have a lot of experience working with police. Oftentimes they are former police, so it makes it a lot easier to kind of have the interdepartmental cooperation. Prosecutors themselves, depending on the level of government and the particular jurisdiction, can be either elected or appointed. Sometimes prosecutors have to run for office themselves and get voted on by the constituency, whether it's the city or the state or whatever. And other times they are appointed by those who are elected, right? So let's say the government or the governor appoints prosecutors in your state. They're still very kind of reactive to public pressure and how the public views certain, especially the bigger cases. Because just because they're not elected themselves doesn't mean they don't have to listen to kind of the mind of the voters. The other kind of big aspect of prosecution that investigators really need to be aware of is that, for law enforcement, in order to arrest somebody, you're held to a relatively low standard. All you need is probable cause to arrest somebody. But prosecutors are held to a much higher standard. They're held to the standard of proof beyond a reasonable doubt. So just because you had enough probable cause to arrest somebody doesn't necessarily mean at the end of your investigation you're going to have enough evidence to convince the prosecutor that there's proof beyond a reasonable doubt, because that's a much higher standard. It can be a lot more difficult to reach that level, and so prosecutors will relatively often say, hey, I know you had probable cause to arrest this person, but I don't think I have it enough here for beyond a reasonable doubt, so I'm not going to prosecute this case, or I'm dropping the charges, or whatever. So that can be really frustrating in kind of the prosecutor-investigator dynamic, right? One of the things prosecutors have to be worried about because of their whole elected or appointed aspect is their clearance rate. And clearance rate, depending on who's defining it, essentially means how many crimes are solved. What percentage of crimes go forward? What percentage of crimes get prosecuted? What percentage of prosecutions are successful? And prosecutors in general have an exceptionally high conviction rate. If they decide to charge somebody, there's a huge, like 90% plus, that they will get a conviction. Because the vast majority of those are people who just accept a plea bargain, plead guilty, no trial, and they go to prison or jail for some reduced sentence or reduced charge from the prosecutor. So prosecutors include those plea bargain numbers in their conviction rate, which causes it to be, again, 90% plus. 97, 98% isn't unheard of. But when you look at just when they went to trial, it's still pretty high, just not that high. But for police, they also have to worry about a clearance rate, as in what percentage of crimes reported to police are they eventually kind of arrest somebody and send it off to the prosecutors to be cleared, right? So murder has a relatively high clearance rate. Of all the murders reported, I can't remember exact numbers, something like 60 or 70% are eventually cleared by arresting somebody and sending them off to prosecution. Other crimes have much lower clearance rates. Auto theft has a fairly low clearance rate. Sexual assault has a fairly low clearance rate. But sometimes investigators can be absolutely convinced that they know who did it, but through some extraordinary circumstances, they can't arrest that person and send them to the prosecutor. For instance, mass shootings. In a lot of mass shootings, the shooter ends up dead at the end of it. And thus, we know who committed those crimes. We know who committed the murders. We know who shot all those people. But we can't arrest them and send them to the prosecutor because they're dead themselves, right? So that's called an exceptional clearance. It's no, we didn't arrest anybody and send them to a prosecutor, but we're pretty sure this is clear. We know who did it. Also, if somebody's already in prison and they confess to other crimes, it may not be worth it to try them and convict them of these new crimes that they've now confessed to because they're already in prison for a very long time or life or, whatever. So we would call those crimes that never actually got prosecuted exceptionally cleared. One of the things that investigators should be aware of with any case are the pretrial motions. So before a trial starts, each side, the defense and the prosecution, get to kind of file motions, which are requests for the judge. Like if you're the prosecutor, you might say, hey, judge, I would like it if this was a rule for the trial, or we excluded or included this thing, or whatever. So there's lots of different kind of pretrial motions that you should be aware of, especially if it's your case. The first is discovery. And this is essentially 100% of all cases will have a discovery motion, which essentially means that the defense is entitled to all evidence against their client. They have a right to know every document, every witness, every piece of hard evidence, all that stuff. The defense has a right to know what the prosecution knows. And that comes out of a Supreme Court case, Brady v. Maryland, 1963, where not only are you entitled to everything the prosecution knows, you are especially entitled to any exculpatory evidence that the prosecution may have. It is not legal for the prosecution to have some piece of exculpatory evidence and just sit on it and hide it. There's also a motion to suppress, which is when one side or the other wants some piece of evidence to be not admitted because it violated somebody's rights when it was gathered or something. You know, if you as an investigator violate someone's Fourth Amendment rights to seize some evidence and then arrest them and send them for prosecution, their defense lawyer is going to file a motion to suppress that piece of evidence because you violated their client's Fourth Amendment rights, right? Or maybe it's motion to suppress some testimony by a witness because that witness is somehow not legally allowed to testify about this thing or something. And then there's the change of venue, which basically means we don't want to hold the trial in this jurisdiction. We would like to move the trial physically to some other geographic position, right? So maybe, it's impossible to find an unbiased jury in this city because everybody knows my client, everybody knows the situations of the crime and what's been reported in the newspapers. So we would like to move this prosecution from this city to another city on the other side of the state or something like that. But that might change the physical location of the trial, which might mean more travel time for you as the investigator if you're going to go testify. Another thing that happens pre-trial is deposition. And deposition is very, very similar to testimony as a witness at a trial. Essentially, the lawyers sit you down. They ask you a bunch of questions, just like they would on the stand. And you are under oath, just like you are at trial, usually. And it's kind of like a preview of how each witness is going to testify at the trial that the lawyers can then use to kind of modify or enact their trial strategy. Importantly, as part of this deposition process, and as part of the trial, what's the word I'm looking for? Speaking at a trial, testimony process. Not only is the defense entitled to any information about that might be exculpatory for their client, they're also entitled to any impeachment evidence against their witnesses. So if you as an investigator have lied on the stand before, the defense in every subsequent case is entitled to that knowledge that you were convicted of lying on the stand in a previous case, so that they can impeach your testimony and make it look like you're a bad witness during the trial. Part of the, more things that happen in kind of the pre-trial process is plea deals are offered. And again, usually accepted. The vast majority of cases are resolved by plea agreement. It's only a very small minority that actually go to trial. Most of the time, the defendant just accepts whatever plea deal they think they can get, and accepts, a very minor punishment compared to what they would get if they had gone to trial and lost. You might be subpoenaed. A subpoena is just a legal document that says, you are legally required to show up at such and such court on such and such date to testify in the matter of Jones v. Jones or whatever. And that subpoena has legal force behind it. So if you refuse to follow it, you can be arrested and forcibly brought to the courtroom. Sometimes judges will just kind of assume witnesses like investigators will show up, but sometimes they issue a subpoena just kind of preemptively. You need to sit down and review your reports by yourself. Make sure, because it might have been years since you actually wrote the report before you're actually going to trial to testify. So before the trial starts, especially if it's been a long time since you wrote the report, you need to review it. Make sure every single thing is correct. If you find any kind of discrepancy or typo or whatever, you need to make note of it, bring it to the prosecutor's attention immediately, which you can do at the pretrial conference, which is usually where the attorney that is going to call you, gets you and often other witnesses all together, has a conference with them about, here's how to do this. Here's how to, make sure you don't do this. Make sure you, have this ready. Make sure you bring this to court with you. And just kind of going over kind of what they're going to ask you, kind of how to respond to the cross-examination from the other attorney, things like that. But it's like a pre-game conference, right? On the day of the trial, you need to dress well, because kind of the entire point of testifying is to make the jury believe you. You want the jury to believe what you are saying is the truth. And like it or not, part of that process is nonverbal. It's not just the words that are coming out of your mouth. It's also your body language, and it's also your dress. So a lot of police departments require that officers testifying in court wear their uniforms. If they don't, you might want to do it anyway, or wear like a really nice suit, or something that screams kind of professional. Make sure you're on time. In fact, be early. If you're 15 minutes early, you're late. Make sure you are there on time, because judges will get really, really upset if they have to wait for you. And then make sure you understand if witnesses are sequestered or not. So in some cases they do this, in some cases they don't. But in many cases, witnesses that are going to testify in the trial are not allowed in the courtroom prior to their testimony. So they're not allowed to hear the testimony of any other witnesses in the case. And what that does is it allows witnesses to answer kind of truthfully and honestly and from their own brain, rather than, witness A gets up and says X, Y, and Z happened. So witness B gets up and says, oh man, I don't remember, I remember X and Y, but I don't remember Z. But that first witness said it, so that must be true. So I'm going to say, I'm going to testify that X, Y, and Z happened also. So it just kind of helps keep witnesses from kind of, copying off each other, so to speak. And it might happen in your case, it might not. So, the trial. The important players in the trial. Obviously, there's the judge. Judge is the person who sits up there on the bench. And during the actual, guilty or not guilty phase of the trial, the judge's job is to be a neutral referee. Their job is just to make sure all the rules are followed, make sure nobody does anything illegal, decide on motions and from each side, the prosecution and the defense. The jury is there, and this will almost always, in felony cases, be 12 random citizens from whatever geographic jurisdiction is there, plus maybe one or two alternates, unless there's a bench trial. And a bench trial can happen if the defense requests it. And this is where not only is the judge the role of referee, they're also the jury. They get to decide guilty or not guilty. So sometimes defense counsel believes that they have a better chance at getting a not guilty verdict from one judge than they do from 12 jurors. So they will request a bench trial where the judge does not only the job of the judge, but also the job of the jury. That's a lot of J words. And then, of course, there's prosecution and defense counsel. That's prosecution is trying to prove the defendant guilty. Defense counsel is trying to prove the defendant is not guilty. And there can often be more than one of each, right? So the prosecution, a lot of times, it won't just be one person. It'll be 2 or 3 or 4. Defense counsel probably won't be one person, 2 or 3, 4, especially in the higher level cases. When you get up to testify, okay, they walk you up to the front of the courtroom, you raise your right hand, do the whole swearing in thing, and then the side that called you will ask you questions. And these are the ones you've prepared for. This is going to be smooth sailing. It's going to be real easy. They're going to have prepared you for all this. It's going to be just like you rehearsed, relatively easy. So if you're an investigator, chances are you're getting called by the prosecution. So the prosecutor will call you. You'll do your direct examination where the prosecutor asks you, what happened on this day, and what did you find at the scene, and what evidence do we have here, and you'll answer those questions in the way you've kind of prepared yourself to answer. Then there's cross-examination, which is where the other lawyer gets to question you. This you can't prepare for. And again, if you were called as a prosecution witness, which you probably will be, the defense counsel will be cross-examining you. So they're going to try and make you look bad. They're going to try and make you look stupid. They're going to try and make you look like you're lying or that you have it out for their client or something. And we'll discuss that more here in a minute. Then there's redirect, which is where the prosecution then can ask you any questions relating to the cross-examination. They can't bring up anything new. They can't go anywhere that the defense counsel didn't go in cross, but they can ask you more questions relating to those same subjects in order to kind of clarify things if needed. It doesn't have to be a redirect. And then, of course, there's a recross if the defense counsel wants to clarify some things from the redirect. But there doesn't have to be. And they can only cover the things from the redirect. So in that way, you can theoretically go back and forth forever, but each time it has to be just the things covered in the previous one. And then sometimes, occasionally, you can get a witness who isn't on the original witness list as a specific rebuttal witness. So if I testify that, oh yes, the 1995 Mazda SUV car, the top speed is 120 miles an hour, but they might call a rebuttal witness to come in and say, no, actually that car can go 150 or what, they can call a special witness just to kind of say that previous witness was lying or was wrong, okay? Now, again, when you're testifying, the most important thing is that you want that jury to trust you. You want them to think you are the most professional, smartest, most careful, detail-oriented person in the planet. Part of that is dressing well. Part of that is being physically calm. Don't fidget. Don't twitch. Don't, do all the things that I do because that can make you seem kind of nervous. And you don't want to seem nervous. You want to seem calm, cool, collected. Make sure you never offer any opinions, right? If somebody asks you, if one of the two lawyers, usually it'll be the cross-examining lawyer, asks you your opinion on something, just say, deflect. That's up for the jury to decide, or, that's my opinion is not important here, something like that. Try to deflect and say, never give any of your opinions. So you can say, the defendant stated that they had 12 alcoholic beverages that night, but don't say, oh, they were drunk. Things like that, right? Make sure you don't violate the rules against hearsay. And hearsay in general is just something someone else said that you heard. You can't testify in court, well, Bob said blah, blah, blah. You have to only testify about what you did and saw and heard and all those things, but not what other people said. There are exceptions to this, such as the dying declaration. If you're an officer, you show up on scene, somebody is laying there dying and say, oh, Billy shot me, Billy shot me. You are allowed to testify that, and then they die. You're allowed to testify that they said, Billy shot me as they were dying, because that person is now dead and can't come and say it for themselves. So there are some exceptions to this hearsay rule, but in general, you are not allowed to testify about what anybody else said outside of the courtroom. If you made mistakes, admit them, point out how you tried to rectify them, and move on in a professional manner. It is much better to admit mistakes and kind of discuss it in depth and show how it's not as big an issue as the lawyer's trying to make it out to be, than to try to deny and lie and, cover up. Speak clearly and simply. How fast was the car going at the time of the impact? Well, sir, the tire marks very clearly show an excessive rate of speed. The impact damage here shows an impact between, 75 and 85 miles an hour, things like that. Make sure that you only answer the question. So one of the classic examples here is, walk up to somebody and say, excuse me, do you know what time it is? Chances are they'll look at their watch, look at the clock and say, oh, it's 3:30. But that's not the question that was asked. They didn't say, excuse me, what time is it? They said, excuse me, do you know the time? That is a yes or no question. So if somebody asks you, do you know the time? On the stand, you say either yes or no. That's it. Don't give them any more of an answer than they wanted with that question. Now, sometimes as an investigator, you'll be called upon to testify as an expert. And whether you qualify as an expert or not is governed by the Supreme Court case. And this is one of those things I've only ever seen written. I've never heard it pronounced correctly before. So it's Dober, I don't know. Daubert versus Merrill Dow Pharma from 1993 that essentially says the judge gets to decide. Whether you're an expert or not in tire track interpretation, or whether you're an expert or not in digital forensics, or whether you're an expert or not in psychology, all those things, basically the judge gets to decide whether you have the credentials and the work experience and all those things to be qualified as an expert and help the jury understand whatever issue they're trying to understand. Now, what are some of the mistakes people make during testimony? Well, if somebody asks you, and how far away was the defendant at the time? Instead of trying to put an exact number, instead of saying, well, he was 50 feet away. If you do that, the lawyer's going to say, oh, well, according to this measurement, he was only 47 feet away. Are you lying? They'll choose any little thing to make it look like you're lying, even if it's the difference between you said he was at 50 feet, we measured it out, and it was only 47. So, instead of giving an exact number, give an estimation, like approximately 50 feet away, or give a range. Say, he was 40 to 60 feet away, that kind of thing. How fast was the car traveling when you saw it, somewhere between 70 and 90 miles an hour? That kind of thing. Give like some wiggle room. If you are criticized, if the defense lawyer tries to kind of say something to rile you up, like, oh, even a first day investigator would know to do that, and you didn't. that kind of thing. They're trying to get you riled up. They're trying to get you emotional. They're trying to get you angry. Don't let them. No matter what that lawyer says, breathe calmly, respond calmly, be clear, and don't kind of rise to the bait that they're trying to get you to take. Don't worry about the silent treatment. So the defense lawyer says, excuse me, do you know what time it is? You say, yes. And then the defense lawyer just sits there silently, waiting. And what they're trying to do there by just being silent is trying to make you uncomfortable with the silence, because then you'll keep talking. They want you to keep going. They want you to kind of keep speaking and speaking and speaking until they find something they can kind of attack. So answer the question, then stop, and give them the silent treatment right back. Don't try to fill an empty silence. Now, another big important thing is never, ever, ever testify about anything that you don't have personal knowledge of. So if there was an investigation and some officer found a gun in the person's right pocket, but you weren't in the room at the time. If the defense lawyer asks you what pocket was the gun found in, don't say it was found in the right pocket. Say, well, according to Officer so-and-so in his report, the gun was found in the right pocket. Or even better, just, I was not in the room, you'll have to refer to the report, or something like that, right? So unless you personally saw it, heard it, smelled it, whatever, don't testify about it. And if you have to, i.e., the lab report says, make sure that you're referencing the lab report. Make sure you're referencing the physical evidence that you found, those kind of things, rather than even coming close to implying that you saw it or heard it or smelled it when you didn't. If there are some minor differences in the stories of the other witnesses on your side, don't worry about it. There's always little minor differences. That's fine. The defense lawyer or the lawyer on the other side is going to try to attack those differences and make them seem much larger than they are. But it would be a lot more worrying if every single person testified to the exact same details 100% of the time, because that implies a rehearsed story. Just like it implied a rehearsed story during interrogation when the defendant was doing it, it also implies a rehearsed story when a bunch of investigators give the exact same details over and over and over with absolutely zero deviation between investigators. So a little bit of deviation is normal and expected. So don't worry about that too much. Try to be aware of when lawyers ask you to give simple answers to complex questions. So a lot of times a lawyer will say, hey, do you think it's possible that such and such and such and such and such and such and such and, and give this big, wild, demanding thing and then demand that you answer it in yes or no. Don't fall for it. Just say something along the lines of, that question is too complicated for me to answer in either yes or no, and then let them either re-ask the question or, whatever. Be careful with rapid fire questions, because a lot of times they'll just do question, and then when you're in the middle of your answer, ask you another question. When you're in the middle of your answer for the next one, ask a third question. When you're in the middle of your answer for that one, ask a fourth question. And they're trying to get you off your game, get you to slip up, get you to either say something wrong accidentally or say something that they can kind of attack as the wrong thing or whatever. In a similar vein, a lot of times they'll address you by the wrong name or the wrong rank just to kind of get you upset. It's that lawyer's job to make you emotional and angry and flustered and nervous. Don't let them. No matter what happens, no matter how insulting, no matter how intense, no matter how weird, no matter how off-putting something is, deep breath, calm, reply, simply, accurately, truthfully, and move on. Now, that's the end of this section. Thank you so much. See you next time.